Welcome to Texas Probate Made Simple under the KISS principle.
Welcome back to Texas Probate Made Simple under the KISS principle. Riley Hetherington is a board-certified attorney serving families across Southeast Texas. His practice focuses on clear, affordable, and non-adversarial solutions for probate and end-of-life planning. I'm Heidi Mack, and on today's episode, we're going to be asking a big question many families have. Can you avoid probate in Texas? Thank you, Riley, for coming and joining us on this podcast today. How are you doing?
I'm doing great. Look forward to visiting with you and hopefully giving some information on some of the stuff that you'll be asking me.
Wonderful, wonderful. Thank you so much. Well, let's get to it here. So Riley, what does an estate actually have to go through probate in Texas? Like why and when can families possibly skip it?
So the term probate is a judicial proceeding to confirm how assets and liabilities of a person who's passed away are handled and disposed of after the person has left the planet. We're going to get in today several discussions about what the difference is between a probate asset and a non-probate asset. And that becomes very important because non-probate assets do not necessarily and are not handled through judicial proceedings of probate in Texas. So what is a probate asset? A probate asset are typically titles to real estate, titles to vehicles, titles to any kind of personal property, all those kinds of things that are in the name of the person who passed away. Uniquely, non-probate assets are assets that are controlled as far as how they're disposed of after a person dies by contract, as opposed to a will or inherency. And those contracts are classically life insurance policies, for instance, as an example, where you own the life insurance policy. It's for a certain amount of money if you pass away. But the disposition of that money after you pass away is controlled by a beneficiary designation on the life insurance policy. And as we go through today, those non-probate assets always come through a separate contractual arrangement that the person has made, typically with a third party holding that asset before his or her death.
It's very interesting because I've had to go through this with my parents, and I didn't know that they actually called it a non-probate item because I just knew that like life insurance was separate. So this is very interesting that you're actually, I'm also learning today as well, as should the audience as well. So appreciate the difference that you're giving us here. So then when we go to the next thing here, what are some of the common ways people can avoid probate then entirely?
Well, I'm going to give some examples. All of these things basically need quite a bit more information and description and how they're handled and what can be done with them. But for instance, typical non-probate assets are the life insurance policy I just talked about. There are also IRAs and 401ks that make up a great deal of a person's net worth at the time that he or she passes away. But they also include accounts that you have at the bank that are styled in certain ways. We'll talk about that, a payable on death account or a joint tenants with right of survivorship account. They also include, in connection with real estate in Texas, certain types of deeds that you can sign before you die that assure that the title to the real estate will go to a particular person. Those deeds in Texas are called transfer on death deeds. There's also another type of deed called a ladybird deed, which we can talk about. Additionally, there are affidavits of heirships and small estate affidavits, and a judicial proceeding which does not involve a full probate called immuniment of title. All of those things in Texas are available as vehicles under which people do not have to file or go through the probate court system and have a judicial proceeding in Texas.
So yeah, like you were just talking about, like at the beginning there, a little bit about the bank account thing. where people can list beneficiaries. So how do those designations then work? How can they help families avoid probate?
So the classic way is two types of accounts. As I indicated, these non-probate assets have to do typically with the third party holding an asset belonging to the person who passes away. And in that case, it would be the financial institution, a bank. It can be a stock trading account, but any type of financial institution. But classically, it's a bank. And in Texas, there are a couple of ways to do that. You can set up an account called a payable on death account, which is paperwork that you will sign at the bank, and you will actually designate, similar to a beneficiary designation, the person that or persons who are entitled to receive the proceeds from the account upon your death. Additionally, you can also set up, again with a separate agreement with the bank, what is called a joint tenancy with right of survivorship account. Now that's where an account is jointly owned, but specifies that the surviving person to the account receives all of the proceeds of the account at your death. That's used a lot with married couples, where instead of just having a regular joint account that you both can sign on, you set up one of these joint tenancy with right of survivorship account. Again, it's a joint account. Both of you can sign on it, write checks, etc. during your lifetime, make deposits. But upon the death of one of the people, everything in the account automatically goes to the survivor. So again, you don't have to go to court. It's contractual, and it goes to the person that you have listed as the survivor.
Now, you had also said about this a little bit earlier. I'm being from Pennsylvania. I've heard of like a simplified estate of some sort, but you were saying there might be some kind of simplified process in Texas for smaller estates as well?
Yes. The big one we have here in Texas is what is called a small estate affidavit procedure. We have in Texas a body of law called the Texas Estates Code, which is all kinds of statutes dealing with how estates are handled, what can be done, time, who gets what, claims, etc. The entire runs the entire gamut of how an estate is handled. The small estate affidavit basically says that you can have two independent witnesses that are not entitled to receive any monies from a person's death. The person has to have died without a will, and the person has to have $75,000 or less of assets at the time of death. However, Texas does not consider the homestead real estate of a person or any exempt assets, which basically are quite a bit of the personal property of that person, to make up that $75,000. So for a lot of folks, the small estate affidavit, if you die without a will, is the quickest and easiest way to confirm who the heirs of the person are at the date of his or her death and what those heirs are entitled to once the person dies. It takes a couple of witnesses. You've got to list all of the heirs. You've got to have addresses. You've also got to have a full accounting of what the person has, all in written form. You have to have two folks that won't receive anything as heirs sign off that they know the family history, etc. It's about a 10-page form, straightforward. And once you file that with a probate court, a judge approves that form. That's the end of the probate proceedings, and anyone holding any assets can distribute them to the heirs that are listed in the affidavit. It's a very compact way and very inexpensive way in relation to a full probate proceedings that applies to a lot of folks here in Texas. The one thing that it does not do, which is very important, is as to real estate, it only allows for the title to real estate to be transferred to the heirs if the real estate is homestead. In other words, the primary residence of the person who passed away. If, in fact, the person owns other real estate, you can't use this procedure. But for most folks have a home, they have cars, they've got some money in the bank, and a lot of them can qualify for the under $75,000 exemption and use the procedure.
That's very interesting. I didn't know any about that, especially with the home not being included in that. Are there, like, I know we were talking about bank accounts, being non-probate and stuff. Are there other certain kinds of properties that never have to go through probate at all?
Yes, and the important ones are the IRAs and the 401ks, which
Oh,
make
okay.
up a great deal of the wealth of an individual at the time that he or she passes away. As I indicated, that's a contract you have with a third party, the third party being financial institution or a life insurance company or uh, E-Trade or any of the major Charles Schwab, any of those kind of accounts that you have where a beneficiary designation is required. The beneficiary designation in an IRA or a 401k controls who gets the money. So you may have a will that says that these individuals are entitled to receive your estate, but the IRA and 401k beneficiary may have a different set of people listed that are going to receive the proceeds from the IRA or 401k, and those proceeds go to the people listed in the beneficiary designation. So it's outside of the will. So those are the kind of assets, and candidly, they're quite overlooked by a lot, even of lawyers, when doing estate planning, that really need to be looked at, dovetailed, and used in the estate planning process.
So then, yeah, are there mistakes then do you see often families do to try to avoid, probate on their own?
Well, most people think if they have a will, everything's taken care of. And as I indicated, the will only takes care of probate assets. It does not take care of any non-probate assets necessarily. And that's a real issue that can exist. Sometimes it is good to have a probate proceeding, depending upon even if there are non-probate assets involved, because a probate proceeding confirms title to those various assets by judicial decree. And a lot of folks really like to rely upon a judge's decision and a final order of a court with respect to ownership. But as far as the use of non-probate assets to avoid the probate proceedings, that's great. But the mistakes I see are that the beneficiary designations are not up to date sometimes. Some beneficiary may have died, etc. And the beneficiary designations might change, and the person might change his or her mind and are not changed accordingly. And so if they're not kept up with, it defeats the whole purpose of trying to use the non-probate assets as a way around having to and avoiding probate.
So does avoiding probate then, does that always mean less stress, or can there still be issues with that as you've been speaking about?
Well, as we discussed in previous podcasts, stress is going to be at any time when a person passes away. It's a very emotional time. It's a time where you're trying to deal not only with the person's assets and payment of bills and funeral arrangements, etc., but emotionally, it's very, very difficult. It's a loss of a loved one, and that can be very stressful. But the biggest problem is that most people are very private, and they don't list their assets. They don't list all the accounts they have. They don't list where they keep the accounts, whether they have safety deposit boxes, whether they have purchased real estate that no one knows about, etc. And that is and can be the most stressful time of a person passing away. And as we'll discuss during these podcasts, I can't stress it how important it is for as much transparency to exist before a person passes away and as much information sharing. That's kind of against human nature because we're all control freaks to a certain standpoint. We don't want everybody to know our business. But the folks that are going to be left behind and that you are leaving things to need to know your business for various reasons. And I always stress with my clients that if you want to avoid as much stress as possible, as much planning as you can do and as much transparency as you can do will relieve their stress immensely.
Well, Riley, as we start getting towards the end of this podcast, say if someone wants to keep this simple, what are your best first steps to make sure that this estate avoids unnecessary court involvement?
Well, I was hoping I was going to get to invoke the KISS principle because I try to live that every day about keeping it simple, stupid. Some of those things apply to me. I think on a daily basis, I wonder how stupid I am about certain things that I should have taken care of, but I try to do the best. And the KISS principle definitely applies to anyone who's trying to avoid probate, or even if they can avoid probate, to be as best prepared as they can be. First of all, K, know to hire a professional partner and team to assist you and have that team explain the process and the steps to be taken, both at the time that the person passes away and certainly, hopefully, before that time with the person making the decisions of his or her assets and what's going to be handled. I initiate the creation of a written plan to handle the process. As I've indicated, very important to be as transparent as possible and to have things in writing as to what assets exist, what liabilities have to be handled in as best as you can, and keep it up. S, schedule time and money to implement that plan. Know that going in, if you are the person planning for which assets and liabilities are going to be handled and by whom, et cetera, upon you're leaving the planet, schedule a time knowing it's going to take some effort, but it's also going to really have to have a plan in place that not only applies when you sign the documents, but also going forward. And finally, survey, the final S. Survey and oversee that plan to the very end on a continuous basis to the best of your ability. So that would be my suggestions of how really time and money can be saved with respect to the ultimate demise of everyone on this planet. And it really, really helps for so many reasons and avoids so much time, trouble, and effort and money if those steps are taken.
Well, like the podcast is titled with the KISS principle, I feel like that's the way we should wrap up this episode with all the information that you gave us. I love that. I love that KISS principle that you got there, Riley.
I'm glad, and it definitely applies. And if everybody can break things down into steps and actions to be taken, it makes life a little less stressful.
And that wraps up today's episode of Texas Probate Made Simple under the KISS principle. If you'd like to learn more about planning ahead and keeping your family out of probate court, visit hetheringtonlaw.com to schedule a consultation. And don't forget to subscribe, leave a review, and share this episode with someone who might need it. Thank you again, Riley, for all your information today.
Thank you very much, Heidi.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.